I use he, him pronouns, and I am the executive director of the Planned Parenthood of Greater New York Action Fund. I'll be your moderator for this evening's event, Gavels Off, Legal Attacks on Our Bodies and the Fight for Our Freedom. Of Greater New York Action Fund joins the federal Planned Parenthood office and affiliate Planned Parenthoods in states across the country for a national week of action in response to ongoing egregious attacks on sexual and reproductive health care access. We stand up tonight's event in solidarity with our sister affiliates in Texas, where anti-abortion politicians, judges, and activists are weaponizing the judicial system and blatantly attacking Planned Parenthood by pursuing a sham lawsuit. While we speak out against those who desire to limit access to care, we also celebrate our volunteers, supporters, patients, and staff who are the essence of Planned Parenthood. You will hear more about the lawsuit later this evening, but it's clear from this case, our opponents in Texas are actively working to strip affordable access to life-saving cancer screenings, wellness exams, sexually transmitted infection testing and treatment, HIV testing and prevention, and other essential healthcare services. This proves once again that these attacks are not only about abortion, but our right to live free, healthy, and happy lives. Thank you so much for joining us during this week of action as we bring together our partners, supporters, activists, and donors to fight for our right to high-quality, accessible sexual reproductive health care. I'm now going to pass the virtual mic to Wendy Stark, President and CEO of Planned Parenthood of Greater New York, our fearless leader, who will offer these evening's opening remarks. Also, if you have questions throughout the program, please drop them in the chat. Thank you.
Thank you so much, Deepal, and good evening, everybody. Thank you so much for being here. As Deepal said, my name is Wendy Stark. I use she, her pronouns, and I'm the president and CEO of Planned Parenthood of Greater New York. Before we launch into our program tonight, I'd just like to take a moment for all of us to hold space, to name the horrific violence happening in our world and all of the fear and rage and grief so many are holding. And so I invite you to join me in a collective breath. Thank you so much. So let me tell you a little bit about Planned Parenthood of Greater New York. We are a leading provider of sexual and reproductive health services and information. We operate 23 health centers across New York State, and we proudly serve 65% of the state's population with over 130,000 visits annually. Our vision is to build a world where all communities have full access to innovative, high-quality, affordable, evidence-based sexual and reproductive health services, which will always include abortion, whenever, wherever, and however they are needed. We know that politicians who oppose reproductive freedom, along with their allies, are trying to sue Planned Parenthood out of existence and are once again weaponizing the courts to control our bodies, our lives, and our medical decisions. That is exactly what we're seeing play out in the meritless lawsuit, Doe versus Planned Parenthood Federation of America. This lawsuit is part of a decades-long strategy to shut down Planned Parenthood and severely restrict abortion access nationwide. In this case, Doe versus Planned Parenthood Federation of America, an anonymous plaintiff falsely alleges that Planned Parenthood defrauded Medicaid systems in Texas and Louisiana by receiving reimbursements for the care we provide for birth control, for preventive health services that we provided to eligible patients. The allegations are patently false. Planned Parenthood did not commit Medicaid fraud. We are a nonprofit organization, nonprofit organizations around the country that follow the law, period. And more to come on that later tonight. This current lawsuit is nothing more than another thinly veiled attempt to defund Planned Parenthood. Policymakers are supposed to help their communities, and instead they're playing politics and trying to take healthcare away from those who need it most. They're playing with people's lives, our lives, for their own personal agenda and gains. We know that these judicial attacks disproportionately impact folks experiencing the most marginalization in our nation. Affordable birth control, cancer screenings, and other basic healthcare are at risk for people with low income, communities who face barriers to healthcare due to centuries of systemic racism, systemic homophobia and transphobia, and discrimination. Our opponents are not only trying to shut down Planned Parenthood, but are blatantly attacking people's rights to healthcare across the country, including access to gender-affirming care. We stand strongly with LGBT+ communities during these trying times, particularly our LGBTQ+ young people who are seeing unprecedented attacks on their rights and dignity across the nation. Tonight is about coming together. It's about learning, about rallying, and about advocating for what we deserve and for the world we want to live in. I am so honored to be joined this evening by experts in this space who are fighting back every day against these blatant and egregious legal attacks on bodily autonomy, especially at a time when we're seeing so much pain and violence in our world. Tonight, you're going to hear from incredible partners from leading legal, reproductive justice, and LGBTQ+ organizations. And we aim to collectively educate all of ourselves, all of you, all of us, on the current legal landscape and leave you feeling hopeful, right? Hope is really critical these days, that we can stand together as change makers for a better future. I believe that we can. We hope that you leave this space armed with information and concrete calls to action. And finally, I want to be very clear. Planned Parenthood of Greater New York's health center doors are open, providing high quality, affordable sexual and reproductive health services to all, regardless of race, identity, sexual orientation, gender identity, zip code, ability to pay. Our doors are open today, and they will be open tomorrow, no matter the outcome of these cases. As we see abortion bans take hold across the country, Planned Parenthood of Greater New York, along with our colleagues, will continue to fight fiercely to stand up care and advocacy for those who must now turn to New York for their health care. It's now my deep privilege to introduce Nancy Davis, an incredible advocate and a patient of Planned Parenthood who has generously and graciously offered to join us today and share her personal care story and why she chooses to fight for Planned Parenthood. Thank you, Nancy.
Thank you, Miss Wendy, and thank you all so much for having me. It is truly an honor to be here. Well, my name is Nancy Davis. I am from Baton Rouge, Louisiana. I have an amazing fiance and 3 beautiful children. The ages are 17, 14, and 2. Last year, we faced a very challenging and distressing situation. To make a painful story short, we were denied an abortion for a non-viable fetus. Initially, we were told the procedure could be done for $6,000, but whenever we went back to actually have it scheduled, they told us we were denied because of Louisiana abortion bans and because the fetus still having a heartbeat. Hold up, 1 second, I'm sorry. Therefore, this forced us to travel nearly 1,400 miles away to Planned Parenthood of Greater New York, where we received exceptional abortion care. I genuinely believe I could not have gone anywhere else in the world and received better treatment than what they had given me. Planned Parenthood is an essential tool. They are an essential corporation in this fight for reproductive justice, offering women and families the essential health care needed. They showered me with so much love, so much understanding, and so much compassion to where it stood out in a world that seemed so confused, so unsure, and so chaotic. For those who actually have misguided information about Planned Parenthood and the services that they offer, it's essential to know that Planned Parenthood services extend far beyond abortion services. I actually started utilizing Planned Parenthood whenever I first became sexually active for STD testing, for birth control, for cervical exams even. And if I'm being completely honest, there were times where I did not have Medicaid, I did not have insurance, and they still saw me and gave me quality health care. They never turned me around. They didn't make me feel less of a human being, and they didn't belittle me. They gave me the same quality health care. So I would also like to say that I still rely on Planned Parenthood to this day for my cervical exams and for my birth control. Planned Parenthood actually is a lifeline for many people all over the world who are in need of essential quality health care. And they are a dependable resource for many of us in our communities. Thank you.
Thank you so much for sharing your patient's story, Nancy. That was incredibly powerful. We value your experience and we respect it. It's never been a more important time to share this experience and show that Planned Parenthood is a vital organization to individuals and to families. We're now going to turn to the portion of our agenda where we'll be joined by legal and policy experts to better understand the landscape of court misuse across the country, how our opponents are using the legal system to restrict bodily autonomy, and how we can fight back. First up, it is my honor to introduce Jenna Lauder, Policy Counsel at the New York Civil Liberties Union, who will offer an update on judicial attacks on sexual and reproductive health care. Please come off mute, Jenna. Thank you.
Thank you, Deepal. As you said, my name is Jenna Lauder. I use she, her pronouns, and I'm a policy counsel at the New York Civil Liberties Union. All of us here tonight know, and Nancy's story just illustrated, that abortion access is integral to our ability to determine our own destinies. It is an inherent aspect of bodily autonomy, and it is fundamental to our equality. And we aren't alone in knowing this. The vast majority of Americans support abortion access, with 85% thinking that abortion should be legal under at least some circumstances, according to a recent Gallup poll. Anti-abortion groups know that abortion is popular. So, as part of their strategy to ban abortion nationwide, and make no mistake, that is their goal, they are increasingly weaponizing the courts to further their assault on access to abortion care without having to appeal to voters. A glaring example of this is one of several cases coming out of Texas, Alliance for Hippocratic Medicine versus the U.S. Food and Drug Administration. This is a challenge to the FDA's approval of mifepristone, one of two drugs used for medication abortion. This lawsuit, brought by anti-abortion doctors and extremist groups, aims to force the FDA to withdraw its approval of mifepristone, which would be unprecedented. Mifepristone has been FDA approved for more than 20 years and has been used safely and effectively by more than 5 million people in the United States. It is used in more than half of all abortions that occur in the US each year. Its safety profile is comparable to Tylenol. Although the legal arguments being used to challenge mifepristone's approval are utterly baseless, the plaintiffs manipulated the court system to ensure that their case would be brought before Judge Matthew Kacsmaryk, a Trump-appointed anti-abortion judge known for his extremist views, who is, not coincidentally, also presiding over several other cases that threaten sexual and reproductive healthcare access. This strategy, bringing their case before this judge, has paid off for plaintiffs. Last April, Judge Kacsmaryk issued a preliminary ruling in this case that accepted essentially all of their arguments and would have entirely blocked FDA approval of mifepristone. Not only did this decision fly in the face of both law and science, but it also used appallingly offensive and stigmatizing language pulled straight out of the anti-abortion playbook. Understandably, the FDA appealed, and fortunately, thanks in part to a Supreme Court stay, mifepristone has remained an approved drug while this case has continued to work its way through the appeals courts. In August, the conservative Fifth Circuit Court of Appeals issued its own decision, which would allow mifepristone to remain approved, but would reinstate medically unnecessary restrictions on its dispensing and use that would severely impede access. The FDA and one of the manufacturers of mifepristone appealed this decision to the Supreme Court, and we're waiting for it to decide whether or not it will agree to hear the case. If the Supreme Court takes the case, access to mifepristone will be in the hands of the same justices that overturned Roe v. Wade not even 2 years ago. And if the Supreme Court refuses to hear the case, the Fifth Circuit's decision will automatically go into effect, massively disrupting mifepristone access nationwide. Although this case originates in Texas, its outcome will impact the availability of mifepristone in all 50 states. The FDA has no mechanism to allow a drug to be approved in some states but not in others, or to impose different rules for accessing it in different places. So we're in a position where Texas judges might have the potential to decide whether certain forms of abortion care remain available to people, even in pro-abortion access states like New York. And this is just one example. Judge Kaczmarek recently presided over a case challenging minors' rights to access contraception without parental consent through the Title X program. He ruled that this violates Texas law and the Constitution, and the case is now on appeal at the Fifth Circuit. And just to be very clear, minors can still consent to their own sexual and reproductive health care here in New York. And then, of course, there's the Doe v. Planned Parenthood case, which you'll hear more about later, that aims to effectively shut down Planned Parenthood nationwide. These cases are being heard in a cherry-picked jurisdiction with the judiciary that is notably opposed to reproductive freedom, and yet their outcomes may impede people across the country from being able to access the care they need. The burden of these rulings will fall hardest on Black, Brown, and Indigenous communities who already face barriers to healthcare access due to systemic and structural discrimination, as well as on young people, people with low incomes, and those who live in rural communities. While abortion is a protected right in New York, there is more we must do to make access a meaningful reality for all people who live and seek care here, including those now forced to travel here from other states. Passing the Reproductive Freedom and Equity Program is an essential step. This would go a long way towards supporting those who lack the resources necessary to access abortion care, including the cost of travel, lodging, childcare, as well as the care itself, by ensuring that there is sustained funding for abortion providers, abortion funds, and practical support organizations, the entities that help individuals navigate otherwise insurmountable barriers to accessing care. Additionally, New York is poised to enact a constitutional amendment that would enshrine abortion rights in our state's constitution. The Equal Rights Amendment is a powerful assertion of intersectional equality. It would prohibit discrimination by the government based on a person's ethnicity, national origin, age, disability, and sex, including sexual orientation, gender identity, gender expression, pregnancy, and pregnancy outcomes, including abortion. The New York State Legislature passed the Equal Rights Amendment in 2 consecutive legislative sessions. And as a final step, it will go before the people for a referendum vote on the 2024 general election ballot. So please turn over your ballots next November and make sure you don't miss it. It goes without saying that this is an unprecedented moment for reproductive rights. Not only is care increasingly and aggressively under attack, but the composition of the judiciary means that long-standing precedent is being called into question, and courts are being manipulated to actively undermine our reproductive rights. Amidst this instability, I hope we can find a thread of opportunity in this moment to reframe law and society's relationship to abortion and bodily autonomy and equality more broadly. And I hope our conversation tonight leaves you inspired to continue to push for more reproductive freedom, more dignity, and more equity than we've had before. Thank you so much. Thanks for having me.
Thank you so much, Jenna. Now we'll hear from Quadira Coles, president of the New Jersey Abortion Access Fund, who will discuss these judicial attacks as a reproductive justice leader. The reproductive justice movement was founded in the mid-1990s by a group of women of color, representing a coalition of Black, Indigenous, and people of color-led organizations. Welcome, Quadira. Please come off mute.
Thank you. Hi, good evening, everyone. And thank you to Planned Parenthood of Greater New York for having me here to offer some remarks. There are three things I want to add to this conversation tonight, and that's one, regrounding us in the three pillars of reproductive justice and Black feminism. Two, highlight one of the strongest strategies to adopt moving forward in this work. And finally, uplift what we should be keeping in mind and asking for as we move into this election season. I'm sure everyone here knows the importance of keeping the three pillars of reproductive justice at the core of our work: the right to have a child, not have a child, and parent children in safe and healthy environments requires deep and continuous commitment and investment of resources across the board. This means adequate school budgets, livable wages, access to healthy and affordable food options, green spaces, clean water, access to affirming healthcare, affordable housing, addressing the criminalization of communities, and obviously so much more. People seeking abortion care will face challenges in one or more of these issues simultaneously. The Black feminist theory on intersectionality reminds us that the responsibility to commit to this work cannot be relegated to the individuals who hold the heaviest burdens of our oppressive systems, and forces us to recognize that this system's intention is to divide and exhaust our labor, which pushes us into working in silos. Being intentional about folding the intersections of our reproductive justice movement, or just the fight to maintain body sovereignty in general, means we are adopting multi-layered strategies, are having productive conversations like this one, and redistributing resources even outside of our immediate scope of work. The purpose of the reproductive justice movement is to think beyond the legal and political implications of our work by linking the social, economic, and public health challenges that will impact a person's ability to be self-determined. Cross-sector collaboration and intersectional advocacy needs to be the strategy going forward. This approach acknowledges that each person's reproductive journey is unique and influenced by a multitude of factors. Intersectional advocacy ensures that the voices of marginalized and underrepresented communities are heard and their specific needs are addressed. Providers, lawyers, policy advocates, practical support, and abortion funds, doulas and midwives, elected officials, and other service providers should be working together, sharing information and data, and recognizing trends to troubleshoot and strategize in a more uniform way to mitigate the burnout in doing this work. We should be drawing connections to and building with other movements like immigration, labor, education, family regulation, criminal justice, reform or abolition, environmental and trans justice, to ensure that reproductive health care is comprehensive and holistic, that our policies and legal strategies are addressing the needs of multiple groups at once, and that there is an equitable redistribution of resources. The full potential of reproductive justice considers all of these things in its work. The restrictions imposed on access to reproductive and sexual health care, abortion specifically, make this work very unsustainable. This is something to keep in mind as we approach this upcoming election season. As someone who works for an abortion fund, we acknowledge the fact that donations will begin to slow down, but we are sure that the demand and cost for care will and are already steadily increasing and saturated in certain areas due to restrictions and bans on reproductive health care. The capacity of clinics and support groups will eventually dwindle. What we are seeing is that the more barriers of accessing care from the very beginning pushes them further into their pregnancy or gestational age, making the cost a lot higher and the risk for criminalization greater. And while people's attention may shift to the elections, we want to ensure that that doesn't undermine the state of emergency we are currently living through when it comes to abortion access. So in addition to more intersectional and collaborative framework in our work going forward, we should also be building up the work and capacity in preventative care. For example, pushing for sex education, emergency contraception, and other family planning items to be affordable, if not free, and more accessible as early as possible is very important. These are some very proactive measures that can significantly reduce, but obviously not eliminate, the demand for abortions and overall support in creating options for people to make healthier decisions. Prevention and early detection allows for prompt intervention and treatment. It is more cost-effective, improves quality of life, and empowers people to be and feel autonomous. Prevention is equitable by nature because it puts control back in the hands of individuals. This is a long-term fight, and we are doing lifelong work, whether it be us or the next generation. And after being in many different spaces and conversations since the fall of Roe, I can confidently say that I believe we are on a right path to reproductive freedom as long as we continue to work together across the board and recognize that everyone's role in this work is equally important and a priority. Thank you.
Thank you so much, Quadira. I want to remind folks that if you have questions, you can please put them in the chat. We'll be collecting them and having a Q&A at the end of the speakers. Now we're going to hear from my colleague from the Planned Parenthood National Office, who will speak in more detail on the case you heard Wendy referencing earlier, Doe versus Planned Parenthood Federation of America. It is my deep honor to welcome Brianna Twofoot, National Organizing Director at Planned Parenthood Federation of America and Planned Parenthood Action Fund. Please come off mute, Brianna.
Hi, thanks, DePaul. Good evening, everyone. Buenas noches. I am Brianna Twofoot, Planned Parenthood Federation of America's National Organizing Director, and my pronouns are she, her, and ella. And thank you to Planned Parenthood of Greater New York for having me, and to Jenna and Quadira for everything that you've shared thus far. I'm here to talk about Doe versus Planned Parenthood Federation of America. And as Wendy said earlier, in this case, the state of Texas and an anonymous plaintiff are suing Planned Parenthood Federation of America and the 3 Planned Parenthood affiliates who provide services in Texas and Louisiana under the Federal False Claims Act and similar state laws. The lawsuit falsely alleges that Planned Parenthood affiliates unlawfully received Medicaid reimbursement for healthcare services provided to patients in Texas and Louisiana, despite court orders allowing the affiliates to participate in Medicaid. It's an outrageous claim, and it's aimed at shutting down Planned Parenthood and access to care at Planned Parenthood health centers. Let me explain the facts of the case, because this is a bit of a long history. This case is the latest front in a decades-long campaign by the state of Texas, Governor Greg Abbott and Attorney General Ken Paxton in Texas, and anti-abortion activists to shut down Planned Parenthood in the state. It's a campaign that dates back to 2012, when Texas sought to remove Planned Parenthood from the state's publicly funded family planning program. That action in 2012 had disastrous effect that continues to be felt today. Removing Planned Parenthood health centers in Texas from their state-funded family planning program cut off care for nearly 45,000 patients and caused Texans to experience poor health outcomes. Not satisfied, though, in 2017, the state of Texas tried to terminate the Planned Parenthood Texas affiliates from Medicaid, the federal program. Represented by Planned Parenthood Federation of America's litigation and law team, the Texas Planned Parenthood affiliates sued to block the termination from Medicaid. They're trying to stay in the federal program in Texas. Through lots of legal meandering, after 3 days of testimony, a Houston federal judge determined that there was, quote, not a scintilla of evidence to justify the termination. Strong language. I didn't know what the word scintilla meant, but basically there is no evidence to justify taking Planned Parenthood in Texas out of Medicaid. And the court issued an injunction allowing the affiliates to continue providing birth control, cancer screenings, and other preventive services to patients insured through Medicaid. So I want to repeat that. The court issued an injunction allowing the affiliates to continue providing care. When the state of Louisiana tried to terminate Planned Parenthood Gulf Coast from its program, a Louisiana judge issued a similar injunction to stop the termination. So while there are injunctions in place, the state of Texas and Louisiana knew that Planned Parenthood affiliates were providing healthcare services, and those states paid the affiliates for those services just as they would any other Medicaid provider. Now, however, Texas and an anonymous plaintiff are claiming that the Planned Parenthood affiliates are required to return the $17 million they were paid for providing services in Texas and Louisiana patients while those injunctions were in place. And they're claiming that retaining those payments somehow constituted Medicaid fraud. Not only that, the plaintiffs are claiming that Planned Parenthood Federation of America, the national organization, is liable too. So in addition to asking for tens of millions of dollars in damages to cover those Medicaid reimbursements, the plaintiffs are seeking $1.8 billion in civil penalties from Planned Parenthood Federation of America and the affiliates. That's billion with a B. As of today, both sides have moved for summary judgment, and we are awaiting Judge Matthew Kazmierik's ruling. That name sounds familiar to some of you, I'm sure. Judge Kazmierik is the same man who earlier this year, as Jenna was sharing, attempted to reverse the Food and Drug Administration's approval of mifepristone, a case that is being appealed to the Supreme Court. If Kazmierik's court does not resolve the case at summary judgment at that stage, and our best guess is that he will not, there will be a 2-week jury trial in Amarillo, Texas. No date has been set, but we currently anticipate it would happen in the late fall or over the winter. So despite the strength of our arguments and the basic fact that this lawsuit is completely baseless, the case does pose a real threat to our work and mission. If Planned Parenthood organizations are held liable and required by Judge Kazmierik to pay substantial damages, it could have a devastating impact on Planned Parenthood health centers everywhere. Planned Parenthood nonprofit health centers serve millions of patients every year, so no doubt the impact could be catastrophic. I do want to say it one more time, though. This is part of a decades-long attempt to shut down Planned Parenthood through cherry-picked courts. And while we all know this, Planned Parenthood is fighting back. So what can you do to support? There are 3 clear actions to take while we're waiting for summary judgment. And I know others later in our conversation will share more that can be done here. But 3 quick things I wanted to name. Learn more at I'm4pp.org. You can sign a petition calling on Texas Governor Greg Abbott to drop the meritless lawsuit. And you can speak out on social media or to friends and family on why you support Planned Parenthood. And let me say a little bit about each of those actions and why they're important. This case is really about what Planned Parenthood means to you and to all of us. The other side is going to try and make this about injunctions and Medicaid reimbursements, a bunch of confusing accusations that are straight up lies and misinformation that defy the legal record. It's all a mask for their true agenda, to close the doors of every Planned Parenthood health center in America that provides sexual and reproductive health care to people who need it. They weren't going to just stop at taking away our rights. They also want to take away our health care. So I want to repeat those 3 things that you can do while we're waiting for this case to progress in Northern Texas. You can start by learning more about this case and why it matters at I'm4pp.org. At that website, you can find a petition calling on Texas Governor Greg Abbott and the Attorney General there to drop this meritless lawsuit. Please sign today. Texans are going to deliver the petition to the governor in the weeks ahead. And of course, the more signatures we have, the clearer it is that we see through their lies. And then you can speak out on social media on what Planned Parenthood means to you. As the case gains traction in the media, it will be essential to keep focus on what's at stake here, the care that Planned Parenthood nonprofit health centers provide to patients. And there's so much more to be done too. I know others may speak to this. There's a 2023 election. There will be state legislative sessions in the spring. And of course, the 2024 election, where we have a chance to elect a governing majority who could work to restore access to sexual and reproductive health care across the country, and ideally appoint judges who wouldn't do a thing like this. So thanks for everything you all do to help keep Planned Parenthood doors open. And I'll turn it back over to Deepal.
Thank you so much, Brianna. Now, we know there is gross misuse of the legal system extending far beyond reproductive rights. There is also targeting and stripping of the LGBTQ, lesbian, gay, bisexual, transgender, and queer communities' rights and dignity happening through the court system. We will be joined now by Alana Redfield, the Federal Policy Director at the Williams Institute at the UCLA School of Law. If we could move to the next slide, please, so Alana can get started. Please come off mute, Alana.
Thank you so much, Dipple. And we can actually go to the next slide, please. So the Williams Institute is an institute at UCLA. It's a think tank that focuses on research on law and policy that affects LGBT people. Next slide, please. We've been studying the laws that have been unfolding across the country that affect LGBTQ people, and in particular, the laws that have been targeting transgender people in state legislatures. Next slide, please. So one big area of focus that really connects with the other topics that we've discussed tonight is gender-affirming care. This refers to treatments that help people live their lives according to how they identify their gender identity. So it could include hormone therapy, it could include puberty blockers, it could include just talk therapy or social transition, and in some cases it includes surgery. It's really important to remember that this kind of care is recommended as a best practice by most medical associations and is supported through years and years and years of evidence-based research. Next slide, please. So Planned Parenthood nationally is one of the biggest providers of gender-affirming care. In particular, 46 affiliates provide gender-affirming care, specifically hormone therapies. And 60,000 patients have received this kind of care at a Planned Parenthood affiliate. So in addition to providing reproductive and abortion care, Planned Parenthood also provides gender-affirming care. Next slide, please. Skip to the next, please. So what you can see, back one, please. the map, yes, that's perfect. What you can see is a map of the US. And in 22 states, there are currently now laws that ban access to gender-affirming care for young people. That's 22 states. 106,000 young people are affected by these bans. And in 2 states, that's Ohio and Wisconsin, those bans, other bans are advancing. So we may see an additional 15,000 young people affected by bans. Next slide, please. We've seen as the bans have been filed, they were challenged in court. And the first wave of laws that went into effect also came with legal challenges. Quickly, we saw that courts were moving to block these bans on constitutional grounds. So they found violations of the Due Process Clause, the Equal Protection Clause, and in some cases, the First Amendment. So that was the first story. Now, the next slide, please. What happened is that last year, the 11th Circuit, which is the legal jurisdiction that includes Florida, Georgia, and Alabama, they issued a decision around access to bathrooms for transgender boys. This is in the school context. And in that decision, they introduced a whole bunch of new reasoning that was then adopted by a bunch of other courts. So in the Sixth Circuit, there were two cases, LW versus Scrimetti and Doe versus Thornbury. And in the 11th Circuit, there was a case, Eknes Tucker, all having to do with these gender affirming care laws. Additionally, there was a case in Oklahoma, and they all applied the same reasoning to the case. So it completely changed the way these cases were turning out. And if you can think, what do you think might have changed? What was the thing that caused the big shift in the way that courts were looking at gender affirming care claims? Next, please. It's Dobbs, right? So I don't mean to take that lightly, but if you look at all these cases, what you're seeing is that the court has then taken the reasoning of Dobbs and applied it in the context of gender affirming care. So what happened is that Oklahoma, their ban was blocked, that was reinstated. Alabama's law was reinstated. Georgia's was reinstated. Tennessee, Kentucky reinstated. And in Missouri, the injunction was denied. So you see lots of different states now have these laws back in effect, and they're all applying the reasoning of Dobbs. Next slide, please. Okay, actually, yeah. So then what I want to note about Dobbs is just that they looked at two different pieces. One piece was the piece about the due process clause and whether there was a deeply rooted in our nation's history or traditions, a right that's deeply rooted. And they found that the right to access gender affirming care for your kids is not deeply rooted. And they also used a very narrow analysis around whether equal protection clause would apply to kinds of medical care that is accessed by, in their words, one sex or another. And using Dobbs as a template, they said, well, gender affirming care wouldn't be protected here. So we're seeing they really quite literally apply Dobbs to use in this other context. Now, the slide you see in front of you now is about Arkansas SB 199. This is because in addition to those first round of laws that were introduced, there's a new round of laws going around. So Arkansas SB 199 was introduced because the court had blocked the gender affirming care law. So this one takes a new tactic. And what it does is it increases professional liability. It expands the kinds of damages that someone can recover in a lawsuit. It imposes rigid documentation requirements, and it requires providers to read a list of factually inaccurate statements to people who are seeking care. So in many ways, this is modeled after a lot of different kinds of strategies used in the reproductive rights kind of space. So all that said, next slide, please. There are a number of ways in which these laws overlap, whether it's state regulation of the way providers can provide care, whether it's enhanced civil liability, whether it's laws attacking anyone who might aid and abet or support or refer someone to get this kind of care, or whether it's combining prohibitions on abortion with gender affirming care or prohibiting travel. There's a lot of similarities and overlaps that we can see in these laws. And I'll end here. So thank you very much for having me.
Thank you so much, Alana. Now, we just set the stage on the legal state of play, but we do have action in our name. This is co-branded as an Action Fund event. And so let's talk about how we're going to work together to fight back and secure our fundamental freedoms. It is my deep honor to introduce Zanelle October, the Executive Vice President of the American Constitution Society for Law and Policy, who will join us for an overview of the judicial appointee process and how we can realize local and federal judges who will fight to preserve access to reproductive and sexual health care. Please come off mute, Zanelle.
Thank you very much for having me on to speak about such an important topic, Deepal. It's a pleasure to be here with Planned Parenthood of Greater New York and my fellow panelists who are all doing such incredible work. Hearing you is just wonderful. So thank you for keeping up the good fight here. The American Constitution Society, ACS, has said it for years. Courts matter, and who sits on them matters. The court's disastrous opinion in Dobbs v. Jackson Women's Health showed the devastating impact that our highest court can inflict on the country. It was the result of a decades-long crusade, as you've heard from others, to fill the federal judiciary, including the Supreme Court, with judges who would overturn Roe. The anti-abortion movement and the far right pursued a nakedly partisan agenda at the expense of our constitutional rights. The Dobbs decision also flew in the face of the court's own restraints on its power. The court overturned nearly 50 years of precedent to reach the result it wanted, creating chaos in its wake and plunging the court's reputation to record lows. As more countries worldwide embrace and strengthen abortion rights, the Supreme Court has taken this country backward by recklessly revoking a fundamental human right so imperative to bodily autonomy. We have seen in the year and a half since Dobbs that enormous harm has been experienced by people in every corner of the country, and the impact has been disproportionately felt by people of color. And we also know that the anti-abortion movement is not satisfied with this result in Dobbs. The decision has inspired litigants to pursue outrageous legal claims, further taking aim at other rights to health care, such as vital gender-affirming care, as you just heard about. They have gone forum shopping, identifying federal district court judge Matthew Kacsmaryk in the Northern District of Texas as a judge they believe will be particularly friendly to their extreme position, pursuing a nationwide injunction on mifepristone and attempting to shut down Planned Parenthood through bogus legal claims. Thus far, he has been willing to try to inflict this partisan and ideological agenda on the rest of the country. We need federal judges who are committed to the rule of law and to vindicating our fundamental freedoms, because we need to counter the likes of Judge Kacsmaryk, who rules according to partisan interests. One thing we always talk about at the American Constitution Society is the need for professional diversity in our judges, which includes reproductive rights advocates. Earlier this summer, we were thrilled to see Julie Rickleman confirmed to a Massachusetts-based seat on the First Circuit. In case folks didn't already know, Julie previously was an advocate for reproductive rights and argued both June Medical versus Russo and Dobbs v. Jackson Women's Health Organization in front of the Supreme Court. Her confirmation was a tremendous step forward, but there is still a lot of work to be done. At a time when our reproductive freedoms are under constant attack, it's especially important that we have more folks like Julie serving on our courts. There are federal judges who have done everything they can to preserve access to reproductive care and protect healthcare providers and patients as they navigate incredibly difficult situations under what are often incredibly unclear laws. And lower courts have been instrumental in blocking some of the anti-trans laws passed by conservative state legislatures that seek to ban gender-affirming care. We need more of these judges on the bench. And bear in mind that these are lifelong positions. So let's talk a bit about how we can do so. First, a brief overview of how the federal judicial nominations process works. Senators, often via judicial selection commissions in their states, will suggest district court candidates to the White House. For circuit court nominees, the White House has a lot more say. The White House will officially nominate folks after doing a lot of vetting. Candidates will have a hearing with the Senate Judiciary Committee, where senators have 5 minutes to ask nominees questions. These are basically mini versions of the Supreme Court nominee hearings you've likely seen, whether it's the hearings held for now Justices Ketanji Brown Jackson or Kavanaugh. After the hearing, usually in a couple weeks, the committee will vote on nominees. If the nominee receives the majority vote, they will advance to the floor of the Senate. Currently, the Senate Judiciary Committee is 11 Democrats and 10 Republicans. So even if it is a party line vote, nominees can advance out of committee. Senator Butler of California recently replaced the late Senator Feinstein on the committee to restore this balance. Once on the floor, the nominee will need 2 votes. A cloture vote, I'm going to get a little too technical here, but stick with me. A cloture vote, which ends debate on a nominee in the Senate. And a confirmation vote, which is the vote to actually confirm the nominee. Over the years, the filibuster has been eliminated for all judicial nominees, so both these votes require only a simple majority. At ACS, we've been discussing several process reforms to help streamline judicial confirmation. Some of these reforms are focused on making the confirmation process more efficient and include the Senate majority can give itself more time during the week. The typical Senate work week is Monday evening through Thursday afternoon, but it is routine to expand the calendar for priorities or urgent matters. And we suggest judges are urgent matters. Working on Fridays or even the weekends to confirm judges should not be out of the question. The Senate majority could also vote to change the Senate rules to make votes on the floor more efficient. This could include reducing post-cloture debate time for circuit court nominees from 30 hours, for example, to 2 hours, akin to that of district court nominees. Enabling multiple nominees to be considered simultaneously would also be a big help. Doing any or all of these things are relatively straightforward and could lead to more judicial confirmation. The other major obstacle to judicial confirmations is the blue slip. For those who might not know, the blue slip is a Senate tradition, which allows home state senators to have a say on judicial nominees in their state. It's important to note here that that's all it is. It's a tradition or norm and not an actual law nor rule of the Senate, so it can be changed pretty simply. So the blue slip is literally a blue slip of paper that's sent to senators. Traditionally, if a home state senator does not return a blue slip showing their support for a candidate, then the nominee is effectively blocked from being confirmed. During the last administration, however, this norm, like many other norms, started to unravel. Under Trump, the Republican chairs of the Senate Judiciary Committee, Graham and Grassley, got rid of the blue slip for circuit court nominees. Merely by having the votes and deciding to do away with this tradition, the blue slip was ended just like that. This allowed the Trump administration to stack our circuit courts with conservative judges, even in states where historically Democratic senators could have withheld a blue slip for candidates from their home state. This included several Second Circuit judges who are based in New York, Judges Bianco, Park, and Menashe. During the Trump administration, the Senate Judiciary Committee still respected blue slips with respect to the district courts. Under the Biden administration and now Chairman Durman's tenure, this same standard is utilized. Blue slips no longer can block circuit court nominees, but they can and do block district court nominees. For a year now, American Constitution Society has been calling for the elimination of the blue slip at the district court level for several reasons. First, and maybe a bit cynically, there's nothing preventing the next Republican president and Republican-led Senate from eliminating the blue slip at the district court level next time they are in power, like they did under Trump with respect to the circuit courts. Second, and most importantly, getting rid of the blue slips now will allow this administration to fill a majority of the vacancies without nominees. Right now, there are 58 current or known future vacancies without nominees. 41 of these are district court seats in states with one or more Republican senators, meaning the lack of a blue slip could prevent any nominee from being confirmed. Most of these vacancies are in the South, in states with high populations of people of color. Particularly, there are many vacancies in Texas, Florida, Missouri. These are the very states where many of our civil rights, including the right to an abortion, are under attack. It is especially important that the current administration is able to appoint fair-minded judges who will vindicate our human and civil rights to these courts. And that's why at ACS, we've been proud to be leading the charge in the call to eliminate blue slips. As of today, 147 Article 3 judges have been confirmed during this administration. For reference, Trump had 187 confirmations through his third year and 234 through his fourth year. I cannot overemphasize how now through the end of this year and all of next year are critical on judicial nominations. The Senate has a unique window with the federal government funded for now and the House in turmoil to focus on doing what only it can, confirm judges. For nearly 2 years, the Senate prioritized judicial confirmation, helping President Biden to appoint more judges in his first 2 years than any of his recent predecessors. The Senate and White House have also made historic strides in diversifying the federal bench. However, the Senate has notably deprioritized judicial confirmation since the summer. It confirmed only 6 judges in June, 4 in July, and 0 in August, when it took 5 weeks off. Since returning to session in September, the Senate has only confirmed 7 judges. This is despite the fact that there's a backlog of 22 judicial nominees on the Senate floor, 11 of whom have been sitting there since before August. Several of these nominees received strong bipartisan votes out of the Senate Judiciary Committee, suggesting their confirmation votes on the floor should not be difficult. Looking ahead, as I mentioned, Trump had 187 judges confirmed by the end of his third year. For President Biden to even tie Trump, the Senate needs to confirm 40 more judges in just over 2 months. In other words, the Senate needs to urgently reprioritize judicial confirmations to avoid risking a repeat of history when dozens of vacancies are left unfilled going into a presidential election. Of course, we've also seen the importance of state courts in the fight for bodily autonomy. As of October 6, 25 cases filed in 23 states challenging abortion bans remain pending at either the trial or appellate levels. There have been real wins at the state level, with state courts preserving access, even temporarily, under state constitutional protections. In several of the states that appoint their judges, ACS is engaging with the state bodies responsible for nominating or appointing judges. In states that elect their judges, ACS is educating and engaging voters on the importance of voting in these judicial races. As we are seeing, state judges are and will remain instrumental in determining access to abortion care in this new post-Dobbs America. Voting abortion must include voting in state judicial races on constitutional amendments and ballot initiatives. Thank you so much for your time and interest, and please engage on judges. If you care about these issues we're talking about today, you have got to care about the courts and who sit on them, whether it's reaching out to your senators to prioritize them or educating your communities on their importance. Please see acslaw.org for more information. Thank you.
Thank you so much, Zanelle. Appreciated your words. And now I'm going to pass it over to my colleague, Miriam Mohammed Miller, our Director of Government Relations here at Planned Parenthood of Greater New York and Planned Parenthood of Greater New York Action Fund, to speak to the Equal Rights Amendment.
Thank you so much, Cecil. Hi, everyone. I am here today again to talk about the Equal Rights Amendment, one of the key tools that we hope to use during this year to combat the federal and state attacks on abortion care. The Equal Rights Amendment would amend our state's constitution to comprehensively prohibit discrimination based on a number of identity markers, including an individual's race, ethnicity, national origin, gender identity, and gender expression, and sex, including pregnancy and pregnancy outcomes, which is critical as we are seeing in states increasingly criminalize not only abortion care, but other pregnancy outcomes like a miscarriage and stillbirth. This legislation, coupled with the numerous legislation that have passed over the last year, post overturning of Roe, will help New York continue to protect abortion access and continue to protect those living in New York State and those forced to travel to our state for care. Currently, our state's constitution does not protect the identity classes that I mentioned earlier, and those are communities that have historically been marginalized. And again, as we see the U.S. Supreme Court and anti-abortion states continue to be hostile to abortion rights, it is imperative that we enact the Equal Rights Amendment in our state's constitution to combat those legal attempts at restricting abortion access throughout our country. And though, like some folks mentioned, the Equal Rights Amendment will not supersede federal abortion restrictions, the ERA can protect us and ensure that we continue to have access if there is a shift in the state government. So things like attempts at enacting a state abortion ban, criminalizing abortion outcomes in our state, and restricting insurance coverage in our state. Again, as folks mentioned, it's important that we pass the ERA, and New Yorkers will have the opportunity to do so in November 2024 during the election. And we want to urge folks to turn over their ballot, vote yes in favor of the Equal Rights Amendment, and again, ensuring that we are updating our state's constitution accordingly.
Thank you so much, Miriam. Next, we're going to hear from another colleague here at Planned Parenthood of Greater New York. Nicole Margiasso, so thrilled to introduce you. Nicole's going to be giving us information about how we can get activated. What are some calls to action and how you can join us?
Thanks, Steeple. Hey, everyone. So grateful to be here with you all tonight. Thank you for staying with us late on a night where many of us have been working already. Really grateful you're still here. So just want to give a special shout out to any supporters, activists, volunteers, volunteer leaders who have been with us for some time. Thank you for being here again tonight. This image you see on the screen is from our May 14th response to the SCOTUS leak of their intention to overturn Dobbs, where we marched from Brooklyn to Lower Manhattan. So go ahead and give a thumbs up or a heart if you were with us on that day, either in New York City or somewhere else in the state or the country. So I'm going to lift up a few things that, as Deeple said, are calls to action. And more so, in addition to responding to this moment, I'm going to also be sharing some ways that you can also just stay engaged with our advocacy efforts in case you are newer to this space. So we've learned a lot of in-depth information tonight. Super grateful for all these experts here to help us break this down and do a deep dive into these judicial attacks. We're also hoping that in addition to this information, you leave with inspiration to resist these attacks and to take action and stay closely connected to our advocacy efforts. So my colleague is about to drop a bunch of links in the chat. And a few of them have already been spoken about, so I am just going to lift them up again. The first three are petitions from Planned Parenthood Federation of America that Brianna mentioned. So the first one is the petition to tell Texas to drop the lawsuit against Planned Parenthood. The second one is for our Spanish-speaking activists and volunteers. Dile a Texas, retire la demanda contra Planned Parenthood. And the third is for Congress. Tell Congress, stop the attacks on Planned Parenthood patients and sexual and reproductive health care. So please sign those corresponding petitions if you haven't already, and please share with your circles. The second big ask we have for you is more personal in nature and brings us back to how we started this teach-in tonight, which was with Nancy Davis's story, the power of her sharing her story and how that brings humanity to this fight, to this movement that we're in. We know, and I want to thank Nancy Davis again for sharing her story tonight. We know that everyone who supports Planned Parenthood or is a fighter within the sexual and reproductive freedom movement has a story why. There's something, that they've experienced or a loved one has experienced that has moved them enough to join in this fight. And these stories are powerful. These stories help to break silence, reduce stigma, support consciousness raising, and education. By affecting hearts and minds, these stories also help us to mobilize our supporters within this movement. So as we are fighting back against these judicial attacks, we are looking to our supporters to consider sharing your story with us. All stories are welcome, and particularly regarding this case, we are interested in stories about how Planned Parenthood has supported people through their healthcare journey, and specifically stories related to Medicaid. We also always aim to uplift BIPOC, LGBTQ+, youth, and other voices of marginalized identities. And all stories are welcome. So you'll see a storyteller form in the chat. If you feel called to, please consider sharing with us, and we deeply thank you in advance. Also in the chat, you will see a link to our organizing team's upcoming events and action page. Please open this page and please bookmark it and check back regularly. This is where we keep a live running list of all of our upcoming actions and events that are open to community. It's a great way to stay connected with us. There's 2 events on that page that I would like to uplift for y'all tonight. One is this coming Tuesday. Planned Parenthood Empire State Acts is going to be hosting a teach-in on sex education about what it is and why it's important. So please consider registering and joining us for that if you can. Another upcoming event that I'd like to uplift, our Raíz team, Latina organizing team, and our Promotores de Salud will be leading an in-person cafecito on Friday, November 10th in Queens. They will be discussing bodily autonomy and abortion within the Latinx community over coffee. If you identify as Latinx and or a Spanish speaker, please, and live in Queens or around Queens, please consider joining us. And again, you can find more information about these 2 events and others on our page. In here, in the chat, there's also another link to join our PPGNY Action Fund. When you sign up, you will receive all forthcoming emails regarding all of our advocacy efforts. Again, another way to stay connected with us, where you'll receive all information about upcoming events and actions that you can participate in. Additionally, you will find handles for our advocacy Facebook and Instagram accounts. Please flex your social media power and follow us and share our posts. And again, lifting up Zinel's call to action. Please engage with judges, whether through flexing your constituent power with putting pressure on your US senators, or paying attention to state judicial nominations, and also voting directly in local judicial elections. Please engage with judges. Have them in mind just as you would any other candidate when election time comes. And on that last note, we have our upcoming election on Tuesday, November 7th. Please ensure that you are registered. If you have moved, please make sure your registration is up to date. And please check in with your loved ones and make sure they're registered and that they have a plan for voting. Thank you all so much for being here with us in this fight, and we look forward to moving forward with you.
Nicole, thank you so much for your words. And so now we've heard from all of our phenomenal panelists, what an exciting group of people who are leading us in this really pivotal time. I want to thank them for their remarks and for really keeping on task and pushing this movement forward. We're now going to be opening it up to question and answer. What I would love to do is have folks, if they have questions, you can put them in the chat. We do have some questions that have already come in before and also that were in the chat. So I'll be asking them to the group. The first question I have is for the group. We heard a lot about the situation right now with court misuse in all different ways. Attacks on reproductive rights, either through counsel that are bringing it in the courts or through forum shopping, where we know there are judges who want to strip people of reproductive rights, LGBTQ rights, lesbian, gay, bisexual, transgender, queer community rights, and more. What can be done? We heard about activating judges. We heard about some policy solutions. We heard about the ERA. Are there any other legislative solutions or answers that might exist in responding to court misuse? And I'm wondering for our folks either at the Williams Institute or NYCLU, the New York Civil Liberties Union, if you might have particular responses to that question, or others.
I'm happy to start us off and certainly welcome others to jump in. I think one of the things that's frustrating about court misuse, especially in cases like the one I talked about with respect to mifepristone, is that there is really only so much that New York as a state can do when you're dealing with a federal court opinion that affects the entire country. So New York certainly is doing all that it can to ensure that people are still able to access care here, to provide protections for abortion providers and patients and those facilitating access to care through its laws. And as I mentioned, to fund abortion care for those who will need to adjust the way that they access care as a result of these court decisions. So it is frustrating that, in this federal system, there really is only so much that individual states can do. And I would just, emphasize what we were hearing from Zanelle about, how important it is that we focus on the confirmation process for more, liberal judges who are going to apply the law fairly.
I can add just a few thoughts. I was really appreciating hearing Miriam talk about the ERA, and it's something that if you think about state constitutions, there's a lot of power there. We just saw a relatively positive decision in Montana, of all places, that has a very strong constitutional protections around equal protection and due process that actually were used to invalidate the state's gender affirming care ban. And while that is likely to be appealed, it's still inspiring to see how the various environments of states can provide protections even when the federal court system is not so great.
Thank you so much for that. Switching to the ERA, the Equal Rights Amendment, here in New York, we do know that there's a ballot measure. You heard about it from a couple of our speakers. Jenna spoke about it, as well as Miriam. For those of us who are just learning about the ERA, the Equal Rights Amendment ballot initiative, if we could crystallize, really specify what makes this ballot amendment so important. This is a question that came in before the panel. What sort of strikes some of you panelists here as the real reason why we need this protection, this ballot initiative to pass here in New York? I might go back to you, Jenna, or maybe to you, Miriam, to see if you have thoughts on that.
Yeah, I mean, I think, what's really, I think, special and powerful about the Equal Rights Amendment is that it employs an equality framework to protect, not only abortion access, but a whole range of protections along multiple axes of identity. And I think, Quadira spoke about how intersectional a lot of reproductive rights and justice issues are. And so I think that the Equal Rights Amendment really provides an important and innovative tool, legal tool, to be able to vindicate people's rights, that cross-cut various forms of equality and discrimination. So, I think it can be a really important avenue for legal change moving forward, in addition to providing that really bedrock safeguard for our rights in the state's foundational document.
Great, thank you so much. This next question is for Wendy and for Brianna. Another question that came in advance of the panel, and it's sort of, where's Planned Parenthood's role in this movement? What sort of is the real value that Planned Parenthood as a advocacy organization can play at this really pivotal time. Wendy, I guess I'll ask you from the more state level in New York, and Brianna, you from a national level. Wendy, why don't we start with you?
Sure. I think there's so much power in combining the provision of healthcare and advocacy together, right? So when we speak as an organization and when we gather our supporters and the folks who receive care from us or participate in our various education programs or whatever the case may be, we speak with the voices of a lot of different communities. We speak as a healthcare provider with direct experience in what we're talking about and advocating for, right? And to sort of add on to the question about the Equal Rights Amendment, sitting here in New York, I think we cannot ever take for granted the state level protections that we have now. And the Equal Rights Amendment is a way to enshrine those protections regardless of who is in office at any given time, right? And those are the kinds of ways that we think about, I think, from the sort of more local or affiliate level for the work that we're doing in our localities and statewide in conjunction with our national office, right? And what's happening on the federal level. We're trying to think very thoroughly about all of the different levels of protection that we need, and bringing that trusted clinical voice into those spaces is so important. So thank you for the question.
I would just echo what Wendy said about the combination of being a healthcare provider and doing advocacy work alongside that, I think is a huge value add nationally in the movement. I do also kind of want to turn the question around though and note how important it is for Planned Parenthood to be acting alongside others. So I do think eventually restoring a federal right to abortion is going to be part of a broader movement to secure gender equity. Because clearly when they come for abortion, they're also coming for gender affirming care. They're also coming for LGBTQ rights. So I do just want to note, I think Planned Parenthood brings strong advocacy work, a lot of supporters, a clear view on healthcare, sexual reproductive healthcare. And, as we move forward and as Planned Parenthood has always done, want to do that alongside the broadest movement possible to secure rights.
Thanks so much for that. And we only have a few minutes left, and I do want to hear from each of the panelists. So we have a sort of wrap-up question. And the question, I hope, inspires hope in those who are listening in. And certainly we have really bright minds tackling this. So the question here is, what sort of gives you hope when you look ahead? When you think about this movement, what is it that keeps you motivated? And it might be sort of charging you at your North Star. So let's start with Brianna.
It's fine if you laugh when I say this. I believe that we are going to win a governing majority in 2024 and restore abortion access in this country and strengthen it. I wake up every day believing that. I will believe it until the results tell me otherwise.
Love that. What about you, Jenna?
Sorry, it took me a second to get off mute here. I hope you are right, Brianna. And I do think that, we always talked about Roe being a floor and not a ceiling. And as horrible and disruptive and, life-changing as the Dobbs decision has been and will continue to be for so many people, it is also creating this moment where I think we are all really galvanized to build something that is better and more inclusive and more equitable. And I hope that that comes to fruition in 2024. And even if it takes a lot longer, I do think that it has created the impetus to really build a more inclusive intersectional movement. So that really gives me hope for the future.
Quadira, thoughts on that? Gives you hope.
Yeah. As I mentioned before, I've been in a lot of different spaces since the fall of Roe. And I must say that a lot of people are thinking more collaboratively and intersectionally about these issues. And it brings me hope to know that people are digging deep into this issue and building stronger strategy across the board. And I say this all the time, the youth give me so much hope. Next month, I can no longer call myself a young person because I'll be 30. But I'm still connected with young people, and they get it and they understand how important this work is, and they're really determined to turn things around. So definitely look to the youth for a lot of hope.
Totally agree. Alana?
Yeah, I love a question. So at Williams Institute, one of the things that our researchers do is demographic analysis. So looking at how many people are LGBT and how do they identify? What is their life experience like? And so one really optimistic thing is that we keep getting more and more LGBT as a population. And I see that as a result of creating more inclusive and supportive environments for people to come out. So I think that creates a lot of room, not only for building a new vision for the future, but also for people to take power, and especially seeing the rise in organizations led by trans women of color who are addressing new and expanding the horizons of LGBT work is really, really inspiring. So I think that will have an awesome policy impact in the near future.
Thank you for that. Zanelle?
Sure, thank you. What gives me hope, people, is people making the connection more that courts do matter. But then it's taken that next step of, okay, how do I engage in that issue? So writing your senators, Gillibrand and Schumer, to say courts matter, they're really important, please prioritize, but also at the state level, paying attention to all of those elections, in educating your community about those elections, because they're a lot and they're difficult to follow, but they're important. So that gives me hope.
Thank you for that. Okay, we have about a minute left, and we've got Nicole.
Thank you, Deeple. I think for me, what gives me hope is truly like our volunteers and our advocacy partners, and just seeing how powerful we are when we are called to come together. I've always been overwhelmed by just the collaborative force that I feel when we're either at collaborative partner events or at leading our own rallies and marches. It just feels like the force of the people, and it makes me feel like this is truly where the power is. And as long as we are here and engaged and resisting and fighting back, we will be the ones to have the last say.
Miriam, what gives you hope?
I think that stories from folks who have historically been impacted by harmful judicial decisions, harmful policies, are centered and uplifted in this moment and are able to mobilize people. I'm continuously inspired by folks like Nancy, Planned Parenthood patients in general, being highlighted as we organize around action. So I think continuing that practice, we'll continue to see some positive impacts on the legislative level, on the community level, to fight back against these harmful attempts to ban healthcare access.
Thank you for that. And Wendy, we'll wrap with you. What gives you hope?
Oh my gosh, everyone on this call, and to join with Qadira and others, the young people, absolutely. And the multi-generational nature of our collaboration and work. My mom's on this call, so I'm saying hi. My kids in the other room listening to, and that to me is just beautiful. Thank you all so much for being here. What a really inspiring evening, and we've got this. It doesn't feel this is not linear, and the fact that we're all sort of sticking with it and in it together is so deeply inspiring and absolutely what we need. Thank you, everybody.
I couldn't say it better. Thanks to all of our panelists for being here. at our program, at our event. We have recorded the event, so we'll have a recording of it for those who would like it. I also want to give my deepest thanks to the staff who really worked hard to uplift these issues. They are core to this movement. They give me the hope. And so thank you to the team here at Planned Parenthood of Greater New York and Planned Parenthood of Greater New York Action Fund, to all of our speakers. And with that, we say thank you. Good night.
Thank you. Have a great night.
Thanks, everyone.
Thank you, everybody.
Good night,
See you
everyone.
soon.